To file an adjustment of status for a parent, or to pursue a green card, who entered the United States legally, several key factors must be considered to ensure eligibility and compliance with immigration law. So here's an overview followed by a little analysis on the steps that need to be taken and some of the basic requirements. So essentially, the adjustment of status process allows certain individuals to apply for lawful permanent resident status, a green card, while remaining in the United States. For a U.S. citizen to file an adjustment of status for a parent, the parent must meet specific eligibility criteria, including lawful entry into the United States. And the U.S. citizen must meet certain requirements as a petitioner. Unfortunately, lawful permanent residents are not eligible to file for their parents and must first naturalize. But this factor is an added incentive for eligible LPRs, legal permanent residents, to naturalize. So what are the basic requirements then? Well, there has to be an immediate relative relationship. So a U.S. citizen filing for a parent is an immediate relative category. The parent must be classified as an immediate relative of the U.S. citizen. Immediate relatives include parents of U.S. citizens who are at least 21 years old. Another requirement of lawful entry: the parent must have been inspected and admitted or paroled into the United States. This means they entered the U.S. legally, which is a fundamental requirement for adjustment of status under INA Section 245A2. Next, a U.S. citizen must file a Form I-130, Petition for Alien Relative, to establish the qualifying relationship. This form must demonstrate the bona fide nature of the parent-child relationship. That form, along with the 485 and some other accompanying forms, must be filed, and it can be filed in one packet. Application to register permanent residence or adjustment of status. This form is used to apply for a green card while in the United States. You also have to consider inadmissibility. The parent must not be inadmissible under U.S. immigration laws. Grounds of inadmissibility can include health-related issues, criminal history, security concerns, and immigration violations. Another consideration is the affidavit of support. The U.S. citizen must submit Form I-64 Affidavit of Support to demonstrate the financial ability to support the parent at 125% above the poverty line, ensuring the parent will not become a public charge. Some other documentation that's supporting these applications includes such documents as birth certificates, marriage certificates, applications that were prior. Proof of U.S. citizenship must be provided to establish the relationship and eligibility, and some other biographical information. So in conclusion, to successfully file an adjustment of status for a parent in the U.S., a U.S. citizen must ensure that the parent entered the U.S. legally, establish the immediate relative relationship, and meet all filing and documentation requirements. The parent must also be admissible under U.S. immigration laws. For citizens whose parents entered without authorization or present illegally, that is a topic that we will be discussing in a separate informational. I'm Jason Mills with the Law Office of Jason Mills, PLLC. Please like and follow for more U.S. immigration-related content.